Getting married, divorced, or transferring property to a family member. You may need to change the name on your Florida property deed, and doing it wrong can cause serious legal headaches down the road. I'm here to walk you through exactly how this process works in Florida, what mistakes to avoid, and why getting professional help can save you thousands. So why do names get changed on deeds in the first place? The most common reasons are marriage, divorce, death of a co-owner, adding a child or family member to the property, removing an ex-spouse, or simply correcting an error that was made previously. In Florida, the tool most commonly used for this is called a quitclaim deed. This legal document allows you to transfer your interest in a property or add someone new to the title. Here's what the process actually involves. The deed must be properly drafted with the correct legal language and property description. It must be signed in front of a notary public, and then it must be recorded with the county clerk's office where the property is located. Miss any of these steps, and you could have serious problems. Let me tell you about the most common mistakes people make. Using the wrong type of deed, having an incorrect legal property description, missing the notarization requirement, or failing to record the document properly. Any one of these errors can cloud your title and create costly problems when you try to sell or refinance later. This is exactly why professional document preparation matters so much. One mistake can cost you thousands in legal fees to fix, not to mention the stress and delays it causes. Don't risk getting it wrong. Noble Notary and Legal Document Preparers will professionally prepare your Florida quitclaim deed quickly and affordably. Visit LegalDocPrepNotary.com or call 321-283-6452. We make it simple.